Hi, everyone. Thanks for joining us. We're going to give folks just another 30 seconds or so to get into the webinar before we get started. So hang tight for just a second. Okay, it looks like most people are in the webinar at this point. So let me welcome you. My name is Tony Wilkin Gibbart. I'm Executive Director of Midwest Environmental Advocates. And for those of you who don't know, Midwest Environmental Advocates, or MEA, is a nonprofit environmental law center that combines the power of law with the resolve of communities facing environmental injustice to secure and protect the rights of all people to healthy water, land, and air. We put our legal expertise in the service of grassroots groups and communities who are working to defend their homes, the people, and the places that they love. And it's an honor to get to work alongside of them. It's also an honor to get to work alongside my colleagues, Dan and Anya, and I'll let them introduce themselves.
Hello, everyone. I'm Dan Gustafson. I'm a senior staff attorney here at MEA, and I've been here a little over 2 years.
Hi, everyone. Good afternoon. My name is Anya Jansen, and I am a staff attorney for Native Nations Partnerships here with MEA, and I've been in this role for just over 1 year now.
Great. Thank you both. We'll be hearing from Dan and Anya in just a little bit. I also want to say at the end of the webinar, we'd like to hear from all of you. We'll leave about 10 minutes for questions. During the webinar, you can put your questions in either the question and answer feature at the bottom of your screen or in the chat, and we'll collect them there and try to get to as many questions as we can with the time at the end of the webinar. Okay, well, to get into our topic, we are here today because, as you know, on January 20th, an incoming federal administration has signaled its intent to dismantle critical environmental protections. And we've heard from many of you that you are anxious and worried about what is to come in the coming months and coming years. And truthfully, to some extent, we are as well. The reality is that if the administration carries through on the promises and the agenda that it has set forward, there will be harm that's done. There will be damage as a result of that. There's no getting around that. But it is also true, and this is what we want to emphasize, that we are not powerless. And it's especially true that we're not powerless in Wisconsin, where we have potent state level environmental laws that are already protecting a healthy environment and natural resources in our state. And these laws can play a greater role moving forward for to act as a backstop and as a venue for progress. So the important point that we want to leave you with is that while the Trump administration may come into power and do its best to roll back environmental policy at the federal level, environmental protection is not solely governed by federal policy. State laws do play an important role. And so this is a bit of a nuanced message. Yes, there's reason to be worried. There's reason to be concerned. In the coming months and years, we're sure to see headlines about this rollback or that dramatic change in policy. The important thing to realize, though, is that the on the ground impact of those news stories, depending on the circumstances, may not be as harmful as it first appears. And regardless, again, what the Trump administration does, there are many things that we can do on the state level to preserve environmental protection here. And that we that I'm talking about, it certainly includes us at Midwest Environmental Advocates, but just as importantly, it includes the larger community of environmental advocates that we're connected to at MEA. It includes other advocacy organizations, it includes grassroots groups, and it includes many of you who have joined us this afternoon. So, the strategies that we want to talk about and highlight these opportunities, they hold significant promise, but their effectiveness is far from certain. They offer us opportunities to work together, to mobilize, and to push our state to lead to meet this moment. We can't predict exactly what's going to happen, but we can know, we do know that what we do over the next 4 years will make a significant difference for the future. And that is perhaps true in a way that is even more profound given the significant challenges that we face on the federal level. Okay, so just to do a little bit of level setting here and to understand what might be ahead in the second Trump administration, we can look back at what occurred during the first Trump administration. And to do that, I want to cite some statistics from a 2023 law review article that looked at the environmental deregulatory agenda of the first Trump administration. This was written by Professor Stephen Johnson, and he and most commentators agree that the first Trump administration came into office and executed on a very significant and aggressive deregulatory agenda. And as evidence of that, during the first Trump term, there were over 100 separate environmental regulations that were repealed, revoked, or rolled back. So that is significant. But when you look at the long-term impact of those deregulatory efforts, the picture is more mixed. When a federal agency has to defend its actions in court, it is usually successful about 70% of the time. However, when first Trump administration deregulatory initiatives were challenged in court between 2017 and 2022, as virtually all of them were, the Trump administration was only successful in about 20% of those cases. So that statistic is itself reason for some sort of optimism here. The first Trump administration was sloppy in its deregulatory initiatives. It didn't always follow the correct procedure, and it didn't withstand judicial scrutiny at the rate that one would expect. However, it stands to reason that perhaps the second Trump administration will learn from some of its mistakes, and so it may be more successful in its efforts in the future. It's also important, and this is something that Professor Johnson in this article highlights, it's also important to account for the fact that the federal judiciary has changed over the intervening years. The federal judiciary that will hear challenges to deregulatory initiatives in a second Trump term is much more sympathetic to deregulatory goals. It's much more skeptical of agency power. And so the second Trump administration may be more successful in defending these initiatives moving forward. That's something a trend that we've seen at the US Supreme Court in recent years, and it's an important trend for us to take account of, and something that we'll come back to at the end of the webinar. So just to summarize that, data from the first Trump administration suggests that yes, there will be an ambitious, aggressive deregulatory agenda. It won't be completely successful, but there's reason to think that it will be perhaps more successful than the first Trump administration. Our main message is that regardless of what happens on the federal level, it's important for us to realize that when it comes to environmental policy in this country, it's not just the federal government that counts. It's not just federal regulation or deregulation that is the whole story. The foundational laws that we have in the US to protect a healthy environment are implemented through some form of cooperative federalism. And what that really means is that there is shared governance between the federal government on the one hand and states and tribes on the other. States and tribes have a big say in how federal environmental laws are implemented and how they affect on the ground environmental protection in their jurisdictions. So let's just talk about that a little bit more. Let's talk about some of the basics of how federal environmental law works and what cooperative federalism really is. So through acts of Congress, federal environmental laws generally set or empower EPA to set national standards, but then it's up to individual states and tribes to implement, enforce, and to tailor those protections to their particular circumstances. And that's true of many of the landmark environmental federal laws that you are likely familiar with. Just to give some examples here, the Clean Water Act. The Clean Water Act is an act of Congress that gave EPA the ability to regulate pollutant discharges to waters of the United States, But importantly, the Clean Water Act also allows EPA to delegate its authority to states and tribes, which it has done in many states, including Wisconsin. And so in Wisconsin, it is the Wisconsin Department of Natural Resources, our DNR, that has been entrusted with implementing and administering the Clean Water Act in our state. And that implementation includes all of the steps, setting water quality standards, permitting, enforcement. It is the frontline agency that is implementing state law and is responsible to the citizens of the state of Wisconsin to do that. Similarly, with the Safe Drinking Water Act. Through the Safe Drinking Water Act, the EPA sets baseline health-based standards for safe drinking water across the country. But often it is states, and that again, it's true in Wisconsin, that actually implement and enforce the Safe Drinking Water Act. And they do this through state laws that are at least as stringent as federal law, but in some instances go beyond federal law. And thirdly, you probably get the pattern at this point, the Clean Air Act. Through the Clean Air Act, Congress empowered EPA to set national air quality standards to protect public health, but it's states that are responsible for actually implementing the Clean Air Act on the ground through state implementation plans. And they set the agenda in terms of what those standards mean in terms of monitoring and permitting and enforcement. So it's true that state laws play, in fact, a primary role in determining how the environment and natural resources are protected. And in Wisconsin, we have a very strong and long-standing legacy of valuing fresh water, of valuing stewardship of natural resources. And over the decades, that value has translated and integrated itself into the laws that we have in the state of Wisconsin to protect an environment. And as a result, we have some of the most forward and potent environmental laws of any state in the country. And those state laws do, in many ways, exceed baseline federal standards. And I want to talk about this a little bit more because it's important for what we'll say later on in the webinar as we give specific examples. In many instances, our state laws go further, or they have the potential to go further than the federal baseline standards that are set by Congress and by the EPA. And there are two ways in which our state laws go further than federal standards. The first is that many of our state statutes and regulations that are doing the work of implementing the Clean Air Act or the Clean Water Act explicitly say that the state is allowed to set protections or standards that exceed the federal baselines. They empower the DNR and other agencies of the state to do that. So, for example, our state's safe drinking water law is how our state enforces the federal safe drinking water law, but it also allows the state to set more protective standards, which the state recently did in 2022 to set PFAS water quality standards before the federal government had even acted to do so. The important point is that federal regulations through EPA that are susceptible to rollback are often just the floor for environmental protection in our state. They're not the ceiling. In addition to all of that, our state has environmental laws and regulations that are separate and independent of federal regulatory programs. A prime example of that is the state's groundwater protection law, which is an issue that the federal government doesn't even directly regulate or address. Our groundwater law protects groundwater resources upon which many communities depend. Again, the takeaway here is that rollbacks that we see at the federal level do not necessarily mean that the frontline laws that are protecting natural resources and a healthy environment in Wisconsin are necessarily going to change. So with that, I'll throw it to Anya, who will talk a little bit more about what federal regulations might be targeted by the Trump administration.
Before turning to some state level opportunities for environmental protection, like Tony mentioned, I'm going to provide a non-exhaustive overview of federal environmental regulatory protections that may be targeted for rollbacks by the incoming Trump administration. One of the overarching themes that we may and likely will see curtailed is environmental justice. Some of the Biden-Harris administration's historic executive orders, federal policy, and grant opportunities designed to address longstanding environmental injustices faced by quote unquote disadvantaged communities, may soon be revoked. And a reversal of such law and policy will harm communities that are already disproportionately impacted by toxic pollution and who are particularly vulnerable to the effects of climate change. In pursuit of their environmental justice goals, the Biden-Harris administration was able to get some rather ambitious environmental regulatory protections across the finish line, some of which we'll highlight here today, and all of which are vulnerable under a second Trump term. The first is an example of EPA rulemakings to protect tribal reserved rights. So in June of this year, an EPA rule went into effect that requires states to consider tribal reserved rights when setting or revising state water quality standards. The purpose of this rule is for state water quality standards to be more protective of the aquatic resources that tribes depend on. Shortly after it was finalized, though, a group of states sued the EPA to challenge the rule as unlawful, and several tribes have since intervened in the lawsuit to defend the rule. This includes Mole Lake and Lac du Flambeau, which are two Ojibwa tribes here in Wisconsin. Especially given this added attention of the litigation, it is possible that we could see this rule on the chopping block when Trump takes office next month. Another focus of the Biden-Harris administration over the past 4 years was to remove virtually all lead service laterals from US water supplies by 2037. Lead, as many of you probably know, is a neurotoxin. It especially affects developing infants and children. And importantly, no amount of lead is safe. The main way children are lead poisoned is through exposure to chipping and peeling lead paint, but exposure through contaminated water is also a significant source of exposure. And this is especially true for formula-fed babies. So it's very important, and removing lead pipes from the nation's water infrastructure, it would be a generational achievement. The funding component of this pathway to lead-free water is the bipartisan infrastructure law. This provided billions of dollars to support local communities with the replacement of lead pipes. The regulatory scheme for becoming lead-free is through the lead and copper rule improvements. This is a now final EPA rulemaking under the Federal Safe Drinking Water Act, and that's the legal obligation requiring all water utilities to replace lead service laterals by 2037. So there is good reason to believe that the bipartisan infrastructure law funding is relatively safe and will likely not be withheld or clawed back by Congress. This is because the funding is benefiting Democratic and Republican congressional districts across the country. However, the EPA's lead and copper rule improvements, these are more vulnerable under Trump's next term. And I'll just note that this week, actually, the American Water Works Association filed a legal challenge to this rule. Next, staying on theme with water quality. Earlier this year, the Biden EPA set national drinking water standards for PFAS under the Federal Safe Drinking Water Act. This rule includes both testing requirements and concentration limits for 6 PFAS in drinking water. And while PFAS are ubiquitous throughout the environment, ingesting drinking water containing detectable levels of PFAS is a predominant exposure pathway. This is why setting health-based drinking water quality limits is one of the most significant steps to regulating PFAS and thus limiting the human health impacts from these forever chemicals. Even at extremely low levels, exposure to PFAS has been linked to an increased risk of cancer and other serious health problems, such as reproductive and developmental complications, thyroid hormone disruption, high cholesterol, negative impacts to the immune system, and more. Young children and pregnant women are even more vulnerable to PFAS exposure. So it's based on this scientific understanding that the legally enforceable federal maximum contaminant levels are set. And as you can see on the screen, they're set very low. And these legal limits are expected to have measurable health benefits. But you guessed it, this rule has also been challenged by water utilities and chemical companies. So its future is uncertain. While on the topic of PFAS, the EPA took action to designate two of the most widely used PFAS, which are PFOA and PFOS, as hazardous substances under the Comprehensive Environmental Response, Compensation, and Liability Act, better known as CERCLA or the Superfund Law. This designation will essentially open the door for stricter enforcement for regulatory authorities and greater accountability for polluters. My colleague Dan will offer more details about this designation later in the webinar. Finally, we want to highlight one more federal rule related to air quality and climate. And this sets stronger standards for fossil fuel fired power plants. So back in April, the Biden-Harris administration finalized new standards that reduce pollution from fossil fuel powered plants. The rule aims to significantly reduce greenhouse gas emissions from existing coal-fired power plants and from new natural gas-fired power plants. Existing coal-fired power plants are the largest source of greenhouse gas emissions from the power sector, and new natural gas-fired combustion turbines are some of the largest new sources of greenhouse gases being built today. These final standards were adopted to ensure that these new facilities are constructed in a way that really minimizes their contribution of greenhouse gas emissions. Specifically, these standards are set to significantly reduce dangerous pollutants emitted by power plants, including mercury, arsenic, lead, nitrogen oxides, and carbon dioxide. So we have some pretty strong federal environmental protections that likely won't survive a second Trump term, but all hope is not lost. We're going to flip the switch here to a more positive note, and probably is the reason why you all are here, to talk about what we can do in Wisconsin to shore up some of these environmental protections. When it comes to protecting the aquatic resources that tribes rely on, Wisconsin can and should adopt state water quality standards that are more protective for these resources. So Ojibwa tribes in Wisconsin have treaty protected rights to hunt, fish, and gather in the ceded territory, or those lands ceded by the tribes to the US government via treaty. So for instance, with or without the federal obligation, Wisconsin DNR could extend greater protection to fish with stricter mercury standards, for example, or to manoomin or wild rice with water quality criteria for sulfates. Those are just a few examples. Wisconsin DNR should also move forward with incorporating PFAS and lead drinking water standards into state law. The State Safe Drinking Water Act allows the state to set even higher standards than EPA baselines. And as Tony mentioned, Wisconsin DNR did so back in 2022 with the maximum contaminant levels for PFOA and PFOS. Of course, that 70 parts per trillion standard is now less protective than EPA's new 4 parts per trillion limit. So DNR is required to codify this more protective federal standard into state code. And indeed, DNR has already started that rulemaking process. Importantly, because state law can be more protective than federal baselines, if and when the new, more protective standards are codified into state code, they could survive federal rollbacks. We need to make sure, however, that the state process of incorporating the new federal limits into state law actually happens, and that special interests and legislators do not interfere with the process. So that is something that we are actively pushing for at MEA. The same is true for the lead and copper rule improvements. DNR is similarly required to codify these rule provisions into state code, and once that rulemaking is or is near complete, the state version would survive federal rollbacks. My colleague Dan is representing MEA in DNR's stakeholder committee, which is working with DNR on drafting this rule. And MEA is pushing DNR to move through the rulemaking process quickly before we see any potential federal rollbacks here. When it comes to protecting clean air and the climate, opposing construction of fossil fuel infrastructure is one method MEA is taking. And we have a couple examples of this to share. The first, MEA's recent challenge of DNR's permitting decisions for Enbridge Energy's Line 5 reroute in northern Wisconsin is a timely example. On November 14th, 2024, DNR authorized Enbridge to construct a new 41-mile segment of its Line 5 oil pipeline outside the Bad River Reservation, but still within the Bad River watershed in the Lake Superior Basin. Just last week, MEA, jointly with Clean Wisconsin, took legal action to challenge DNR's permitting decisions. And MEA is representing Sierra Club, League of Women Voters of Wisconsin, and 350 Wisconsin in this matter. We're challenging three aspects of DNR's permitting decision. First, the wetland fill and waterway crossing permit that DNR issued, which authorizes the construction of the reroute. Second, DNR's grant of coverage to Enbridge under the Wisconsin Pollutant Discharge Elimination System general permit, and this would regulate construction site stormwater discharges to waters of the state. And third, DNR's grant of water quality certification to Enbridge, which is DNR's determination that the reroute would comply with Wisconsin water quality standards. We maintain that Enbridge is not eligible for the permit, which was unlawfully issued, and that the reroute would cause significant adverse impacts to both surface and wetland water quality in violation of state water quality standards. By filing our petition for administrative review, DNR's permit decisions are stayed or paused unless or until an administrative law judge decides otherwise. We are confident, however, that the permitting decisions will remain stayed given the irreversible adverse impacts to the environment that the reroute would cause. Ultimately, if DNR grants our petition for a hearing, an administrative law judge will have the job of deciding whether or not DNR lawfully permitted this project. I'm going to stop there and turn it over to Dan, and he will continue with another opportunity for state-level clean air and climate protection.
Thanks, Anya. So I have one more example of an opportunity that we're taking to challenge some energy infrastructure projects. Earlier this year, MEA joined the Clean Economy Coalition of Wisconsin, which is a broad coalition of businesses and nonprofits that are working together to drive Wisconsin's future towards a clean economy. One of the areas they work in is the energy sector. And currently, Wisconsin's electric utilities are proposing to spend over $2.5 billion on new gas-fired generation projects. In opposition to those projects, CECW recently launched its Power Wisconsin Forward campaign, which is organizing opposition to those new fossil fuel-fired generation projects based on their public health effects of their air emissions, climate change concerns, and the cost of those facilities and their impact on utility rates. Members of the coalition are working together to oppose facilities proposed by We Energies in Oak Creek and Union Grove, Wisconsin, and as well as Dairyland's proposed Namaji Trail or NTEC facility up in Superior. Our role, our most direct role in this respect, is we were contacted by a group of community organizations in Beloit earlier this year. And we've taken on a representation of 4 of those groups to oppose construction of Alliant Energy's Riverside Enhancement Project, a small but expensive gas-fired project there. We're representing 4 groups: Healthy Climate Wisconsin, Wisconsin Eco Latinos, Good Trouble Beloit, and the League of Women Voters of Beloit, both before the PSC to challenge what we feel is a flawed environmental assessment process by the Public Service Commission. And we're also helping those organizations submit public comments on the air permit process that's pending at DNR. This is partly in response to some local citizen monitoring that those groups have organized in Beloit that show that Beloit may already have some of the worst air quality in the region. Now, shifting gears to another area in which we're trying to hold the line against attempts to undermine state level protections. I'll provide, let me back up a minute. State laws can serve as critical tools to protect Wisconsin's environment in the face of efforts by the Trump administration to deregulate at the federal level. However, those state laws have often been targeted by special interest groups who seek to undermine them. Effective environmental protection may hinge on our ability to hold the line against those kinds of attacks. I'm going to talk about 2 litigation matters that MEA is involved in, where we're trying to defend those state level laws against challenges by Wisconsin Manufacturers and Commerce, or WMC, which is Wisconsin's largest business lobbying group. The first of those is a case called Wisconsin Manufacturers and Commerce versus DNR. You'll recall that when we were discussing federal regulations, Anya talked about one of the federal environmental regulations related to toxic substances that the Trump administration may attempt to roll back is the designation of PFAS as a hazardous substance under CERCLA. That designation was one of the Biden administration's major regulatory accomplishments, and along with the adoption of the PFAS drinking water MCLs, represents an important way in which the EPA has moved the ball forward, updating key environmental laws in response to advances in scientific knowledge regarding PFAS toxicity. CERCLA, the Comprehensive Environmental Response Compensation and Liability Act, or Superfund law, addresses remediation at sites of toxic contamination. And because PFAS have been designated as a hazardous substance by EPA, the agency can require responsible parties, including current and former owners and operators of contaminated properties, to investigate and remediate PFAS contamination. While CERCLA is an important federal law, many of its core provisions are also found in Wisconsin's state spills law, which also regulates releases of hazardous substances. And in some ways, the spills law is even more powerful than its federal counterpart, because when the spills law was enacted over 45 years ago, the Wisconsin legislature drafted the law in a way to impose reporting, testing, and remediation obligations on responsible parties for the release of any hazardous substance. Those responsibilities exist regardless of whether a substance has been designated as hazardous through state or federal regulation. Therefore, Wisconsin's spills law already imposes those obligations on responsible parties, even before the federal CERCLA designation for PFAS. But it's that feature of the spills law that WMC is seeking to challenge in court. This case was filed back in 2021 in circuit court, and we've been involved on behalf of our clients as amici, or friends of the court, filing briefs at the circuit court, Court of Appeals, and now at the Supreme Court level. What WMC argues in this case is they're trying to convince the courts to reinterpret the spills law so that DNR is required to designate and establish standards for each hazardous substance before regulating them, even though that's never been the way that the spills law has worked in its 45-year history. Because, as I said, the way the spills law works is hazardous substances are defined very broadly in the spills law to include any substance that poses a threat to the environment or public health based on the specific properties of the substance, the concentration and volume at which it's discharged, and any other site-specific circumstances of the discharge. WMC is targeting DNR's efforts to hold PFAS polluters accountable, as an example of DNR's supposed unlawful implementation of the spills law. If it succeeds in getting the courts to reinterpret the spills law, WMC's interpretation would turn the spills law on its head and effectively operate as a repeal of that bedrock law. Because before the DNR could take any action under the spills law to address PFAS or any other hazardous substance, it would essentially have to promulgate rules that anticipate every circumstance where a discharge of a substance might create a hazard. And that's really an impossible task, particularly given the way that the legislature has made the rulemaking process so difficult in Wisconsin in recent years. So, as I mentioned, MEA is representing amicus parties in this litigation. It's made its way from the trial court level to the Court of Appeals, and is now pending for decision at the Supreme Court. And earlier this year, my colleague Rob Lee has been involved in this litigation from the beginning. And earlier this year, we filed an amicus brief on behalf of our clients, Citizens for a Clean Wausau, the Clean Water Action Coalition of Northeast Wisconsin, River Alliance of Wisconsin, the Wisconsin Environmental Health Network, and Doug Oetzinger, who's the former mayor and council person in Marinette, Wisconsin, which has PFAS impacts. So we're expecting the oral arguments in that case will happen in mid-January, and we'll be watching that to see what the Supreme Court does. The last example that I have is another case that WMC is involved in, and it's called the Wisconsin Dairy Alliance, the DNR. WMC filed this lawsuit on behalf of two industrial agriculture organizations, Wisconsin Dairy Alliance and Venture Dairy Co-op. And the case could have significant ramifications on whether Wisconsin's environmental laws will be an effective backstop to possible federal rollbacks. The case involves DNR's application of the Water Pollution Permit Program to concentrated animal feeding operations, or CAFOs. Surface and groundwater quality impacts, including contaminated wells caused by industrial farming operations, have long been documented in Wisconsin, and MEA has been involved in both regulation and litigation involving CAFOs and CAFO permitting decisions since our inception. My colleague Adam Voskuil is primarily involved in this area on behalf of MEA. And just to give you some background, current law requires CAFOs with 1,000 or more animal units to obtain a water pollution permit if they store manure or process wastewater in a structure that is at or below grade, or if that manure or processed wastewater will be spread on fields in the surrounding area. But in this lawsuit, WMC rather alarmingly alleges that DNR doesn't have the authority to require CAFOs to obtain water pollution discharge permits at all. One of the main issues in the case is whether the Federal Clean Water Act acts as a floor or a ceiling for state permitting of CAFOs in Wisconsin. WMC has argued that because EPA does not require all CAFOs to apply for permits under the Federal Clean Water Act, that Wisconsin cannot require all CAFOs here to go through the permitting process. Therefore, the outcome of this case is important on two levels. First, since the CAFO permitting requirement is the main source of environmental oversight for industrial scale farms, losing this requirement would be a significant blow for environmental protection in Wisconsin. Second, the case could have a significant impact on whether and how our state laws can act as a backstop against potential future Clean Water Act rollbacks. In this case, MEA represents the Wisconsin Farmers Union, which is a member-driven organization that represents the interests of family farmers who believe in both sustainable agriculture and protecting water quality in rural communities. MEA, Wisconsin Farmers Union, and our partners won a favorable decision in early 2024 at the trial court level in Calumet County, but the case will be making its way through the appellate courts for at least several more months. MEA in August filed a petition for bypass to take this directly from the Court of Appeals to the Supreme Court level. We haven't had action on that petition for bypass yet, so we'll be monitoring that, the court's handling of that case. And now I'm going to pass it back to Tony.
Thank you so much, Dan, and thanks, Anya. So to bring us towards a close here, of course, we've talked about opportunities that we have in the state of Wisconsin to be a backstop against federal deregulation. But to stress, as I said at the beginning, the ability of our state to rise to this challenge, to do this, is not automatic. And there certainly will be political barriers, there will be procedural barriers, there will be barriers about the capacity of our state agencies to handle the task before them. Those are all, that's all true. But I want to focus on three reasons that we have to be optimistic in the state of Wisconsin and why I think we can meet this moment. The first is that the power of administrative agencies in Wisconsin here is increasing rather than decreasing. And this relates back to what I said at the beginning of the webinar about the role that the federal judiciary and the US Supreme Court has played in weakening the power of agencies on the federal level, weakening the ability of the federal government to respond to address clean water and climate. And it's that trend that existed before the election and is just inherent with the makeup of the federal judiciary right now, existed regardless of the results of the election. Regardless of the results of this last federal election, the ability of the federal government and EPA to respond to the toughest challenges we faced was questionable at best, because the Supreme Court and its jurisprudence has undermined the ability of federal agencies to take those kinds of actions. That's all true on the federal level. However, on the state level, the trend line is exactly the opposite. The effectiveness of agencies to protect a healthy environment is increasing rather than decreasing. It's true that over the last 10 to 15 years, many of the deregulatory ideas that are behind and motivating the federal court decisions that have recently limited agency power on the federal level, those were attempted and tried here in Wisconsin on the state level. In some ways, we've been a proving ground for some of those harmful ideas. But we're in the process, and in some cases we have already moved past those barriers. And some of those successes relate to decisions of the Wisconsin Supreme Court, where MEA has had the opportunity to play an important role, including in the Kinnard Farms decision, which affirmed the authority of the state to protect water quality from the effects of CAFOs through permitting decisions, and the Evers v. Markline decision earlier this year, which affirmed the authority of the DNR to make stewardship grant decisions independent of legislative interference. Those are positive trends that suggest that our state is better equipped to meet this challenge. A second reason for optimism is the fact that we now have fair maps in the state of Wisconsin. Any significant new environmental regulations or protections will likely need the consent of the legislature in the coming years. And under the FAIR maps that are now in place, many advocates around the state are optimistic about the fact or the possibility that in 2026, we may have pro-environment majorities in the state legislature, because that will be our first full legislative election cycle operating under FAIR maps. So that's an important opportunity. There's a lot of potential there, and we need to start preparing now to realize that potential opportunity. And the third reason that we have for optimism in Wisconsin goes back to what I alluded to earlier as well. We have a vibrant community of advocates and concerned citizens and champions of environmental stewardship in this state. Over the last month, I've had the chance to talk with a lot of grassroots activists, coworkers, and colleagues, folks that we work with on a daily basis. And I've heard from them that they have no intention of slowing down as a result of the federal election. Through some of the opportunities that we've suggested here today, that we've pointed to, and many others, I'm confident that we will be able to act on the shared values that we have here in Wisconsin. And I'm confident that we will make a lasting difference in the coming years and beyond by working together. So part of that confidence, I think, is in part because we had such great interest in this webinar. So thank you everyone for being here. And as I said, we want to try to get to some of your questions in the next 10 minutes or so. And let me pull up the questions right now and try to take some of them. One question relates to whether the federal government provides funding to the state DNR to implement the Clean Water Act here in Wisconsin, and whether that funding is at risk. I will say that's a complicated picture. It's a very good point behind that question, that the capacity of state agencies to handle the challenges ahead is a very important one, and that often means that we need to protect funding that supports that important work. The federal government does provide funding to states through, I believe it's Section 106 of the Clean Water Act to set water quality standards and to do basic administrative work. I'm not off the top of my head sure of what the exact percentage of state versus federal funding is for the DNR here in Wisconsin. I think it's important to realize that the administrative actions that we've talked about, the deregulatory efforts that could happen at EPA, generally only require the executive to act, whereas repealing existing funding or taking back existing funding would require Congress and the signature of the president. And although the outlook in Congress is not great, there are only narrow governing majorities. The funding that we're talking about under Section 106 supports red states, blue states, and I think there are reasons to be more confident about those kinds of funding initiatives surviving potential cuts relative to the kinds of rollbacks that could happen just from EPA. But it's a reason for us all to be vigilant for sure. And in Wisconsin, in a purple state, we have Congress people on both sides of the aisle that are in swing districts. And that if those kinds of cuts are proposed, we need to be talking to them about why it's important that we maintain water quality in the state of Wisconsin. Okay, so thanks for that really good and insightful question. Let's see here. EPA has recently approved conservation as a goal to be considered with the same level of land use as industry through the Department of Interior. Do you think this new policy will withstand Trump rollbacks? I'm not familiar with that exact EPA policy. I do think that those kinds of considerations are the ones that are most vulnerable to there being changes. It's similar in many ways to the environmental justice considerations that Anya mentioned in the webinar, when the administration through executive orders has prioritized certain considerations over others, though the executive generally has wide latitude to shift those priorities. Let's see here. Another person asks, do tribes, and maybe this is a question for Anya to take in the first instance, do tribes have financial resources to bring forth and win cases at the state and federal levels?
The answer here really depends on the tribe, right? So different tribes have different levels of resources and capacity to either use their in-house tribal council or hire out lawyers to take on these cases. There really isn't one size fits all like formula here. I should note though, when I was talking about MEA and Clean Wisconsin's joint challenge to DNR's permitting of Enbridge's Line 5 reroute, the tribe that's the most involved in this case, of course, is Bad River, and they have hired Earth Justice, a group of attorneys. A lot of attorneys and law firms will provide low cost or pro bono support, to assist tribes in these types of legal matters. But yeah, the answer really it depends on the tribe. Tony, you're still muted.
Oh, I just muted myself instead of unmuted. Thank you. Another question, the person asks, I thought there was a federal decision that states and local standards cannot exceed federal standards. Did that not pass? So that is also a very good question. And we've, in the limited time that we've had here, we've spoken in generalities and broad strokes, especially as it relates to the Clean Water Act, the Safe Drinking Water Act, and the Clean Air Act. It is true that in certain situations, federal laws do preempt state laws, or there are portions of the implementation of those federal laws where the federal regulations do set more of a ceiling than a floor. As Dan mentioned, the DNR v. WDA case about CAFO permitting is all about that question. Are the federal permitting requirements a ceiling for Wisconsin, or can Wisconsin be more stringent and more protective? So some of these questions do play out in court cases, one of which we're currently involved in litigating. But I will say, as a general matter, when it comes to the protection of the environment and especially water quality, states have a primary role to play inherent, and states and tribes have a primary role to play that's inherent in their sovereignty. Their authority over the protection of those resources is paramount. It's the federal government that comes in and offers baseline standards that apply because of interstate issues, and the state and tribal governments that have the inherent authority to protect those resources. So their latitude in those areas is quite broad. Anything that either of you would add to that? Okay. Dan, I think we've got a question for you, and I'll just try to summarize it. It's about this issue that's played out in a variety of circumstances around expanding the grid. Many folks argue that we need to expand the grid because we cannot meet greenhouse gas reduction goals without quickly building out renewable energy and grid infrastructure to transfer that energy around the region and around the country. So the person asks, how do we encourage necessary electrical system upgrades and still discourage grid development in our backyard?
Yeah, I mean, that's a great question, and I don't think there's an easy answer to it. You correctly point out that many in the environmental community have opposed expansions of the transmission grid for years, but we do need sufficient transmission resources to to bring power from renewable resources that are coming online to the communities where they need power. So it's a tough decision. I think it's something you have to look at a case by case basis. I would also add, not so much with respect to transmission planning, but with respect to generation planning, that and this is another issue that the Clean Economy Coalition has taken up. We don't have a comprehensive planning process on a statewide basis that is looking at generation projects. And we've advocated for an integrated resource planning or IRP process that would look at that on a broader scale and decide about what projects are needed and what projects aren't at a state level rather than at a utility specific level. So I think that sort of statewide planning process is part of the answer to the question of whether these things are needed and when they're justified and when they're not.
Thanks a lot, Dan. The last question that I think we'll be able to get to is about what are 3 things that individuals can do. Some of the things that we've suggested here today, the commenter says are great, but what can individuals do? I'll list a few things, and then Dan and Anya, feel free to share as well. One, I think it's important for folks to get involved with local groups or groups where they think that they can have an impact. MEA works by representing grassroots groups and other environmental organizations. That's the main way that we collectively build power. So as Anya mentioned, for instance, in the Line 5 matter, we are representing, among other groups, 350 Wisconsin, which is a grassroots group of climate activists that are opposed to Line 5 and doing a dozen other things, at least, to help transition us to a clean energy economy and to address climate change. There's so much power in that kind of grassroots organizing. Another thing I'll mention is and I know this sounds like a cliche, but to be in touch with your state representatives. One theme of today is that our state will have to play a stronger role in environmental protection moving forward. The federal government is not going to save us. And so it will be up to our state officials, both in the executive branch, but also our legislators, to have a role in leading the state forward. So as much as you can establish relationships with those local officials to make sure they understand what you care about and the issues that you're tracking, that lays the groundwork for the state to take action and for there to be political will and budget priorities that enable some of these opportunities to move forward in a successful way. The last thing I guess I'll mention is to vote. That's very, very important now and moving forward. We've talked about the role that our state needs to play, and we have important elections coming up with the state Supreme Court and then beyond. And folks organizing and working on a local level can make a huge difference in the level of participation in those kinds of elections. Anything else that you would want to add, Dan or Anya? Okay, I know we're short on time. We've probably got more ideas, but we should wrap up. And so before we close, again, I want to thank all of you for being here with us. And I especially want to thank MEA's supporters, especially this time of year, the season of generosity. I just want to point out that the resources that we have to do this work comes from private donations and grants. We don't take any government funding, and that means that we have the freedom to be responsive to communities and to push both the state and the federal government to fulfill their obligations to protect our rights to a healthy environment. So thank you so much for those who support us. For those who want to get more involved or know more about what we're up to, please go to our website to sign up for our newsletter if you're not already a member. We've got our podcast available there. If you haven't listened to that, it's excellent. And while you're there, if you're inspired, please consider making a gift to MEA. It means so much to us and is, at the end of the day, what allows us to do this work. So thank you so much. And again, thank you all for taking time out of your day to join us. We truly are optimistic and ready and resolved to meet this challenge and energized for the work that we have ahead of us in 2025 and beyond. Thank you for being part of the community that supports those efforts.
Thank you.